it's a great pleasure to participate in this event. My name is Belén Martín. I am a privacy lawyer, and I'm going to be talking about one of the most controversial issues for companies that are using blockchain technology. To understand the impact of the right to be forgotten in blockchain technology, we need to look at the reasons behind the GDPR. As you can see, the GDPR purpose was to empower individuals to control their data. It was also put in place to address any challenges that were brought to the protection of data by new technologies. And it's a technology-neutral regulation, which means that they don't favor any technology. So the stakeholder will decide what technology to choose, but it has to be in compliance with the GDPR. The GDPR was written during the rise of one of the most disruptive technology, which is blockchain. However, the regulation is based on a centralized system of data management. To the opposite, blockchain, which means, that the regulation doesn't really address the peculiarities of the blockchain technology, which are decentralization and immutability. Now, we have the right to be forgotten. The right to be forgotten entitles any individual to request to a company that is processing their data to delete their data from their databases completely without undue delay. Undue delay means 1 month. So they have to do this in 1 month from request. Now, but there are some exceptions. So the right is absolute. So that means that any blockchain company going backwards. That means that basically there are some exceptions that apply. One of them is the fact that they could keep processing the data based on other grounds, such as what is called the legitimate purpose. The legitimate purpose is a business purpose that a company can have. There are other bases, such as, for instance, you can keep processing data if you need to use it for bringing a legal claim or to defend from a legal claim. So basically, blockchain companies can use that in a case that someone requests them to delete the data to keep processing the data. Now, what does it mean for companies that are using blockchain? Well, the reality is that it is clear to everyone using blockchain that the technology needs to be adapted to the GDPR. Now, blockchain has come to stay, started with cryptocurrencies 9 years ago. It has moved to other industries, HR, finance, and more to come. But the truth is that the technology has the potential to bring an immense economic benefits. I mean, they said that by 2022, there will be a cutting cost of $20 billion per year. Now, as we see what are the benefits of the blockchain technology, it is also true that the right to be forgotten is necessary in an area where there are scandals about the protection of privacy. So what are the tensions between the right to be forgotten and the blockchain technology? Well, the right to be forgotten is one of the main threats to the use and development of the blockchain technology. Why is that? Well, from a GDPR perspective, there is always a controller. There is always a company that takes account of the obligations under the GDPR, to whom the data subject will turn to exercise the right, but that doesn't happen in blockchain. Blockchain, because it's decentralized, there is no manager, there is no key administrator that will really comply with these obligations. So we don't know who is the controller, and also, since we don't know who is the controller, we really don't know where the data is being processed, right? We don't know what law applies. We don't know what jurisdiction applies. So everything is in the air. The other characteristics of blockchain is immutability, which basically means that once the data is inserted, the ledger cannot be changed. And that is really an obstacle to the exercise of the right to be forgotten. Now, of course, another challenge is if a data subject places a request to a company, the company says, sorry, we cannot remove the data. he will probably file a claim with the Data Privacy Agency. And that may result in fines, which are quite high based on the regulation. They can go from 20 million to 4% of the annual gross revenue, so it's quite high. Obviously, the data subject can also file a lawsuit claiming damages, and he can ask for a court order to compel the removal of the data, or even to shut down the computers that are within the network. So as you can see, there are a lot of challenges. Now, from an enforcement perspective, it's very hard, because we don't know what is the controller, we don't know where to file the lawsuit, where to serve the papers. But in any case, we have seen that regulators start qualifying controllers, and they consider that entities that write in the chain and then send the information for validation are considered controllers. Miners are considered processors, and software developers are considered processors. So we see that the regulators now are giving us some clue as to what are the figures in blockchain in relation with the GDPR. Now, the last one is lack of legal certainty and clarity. It is true there are guidelines out there. Since the GDPR came into place, there were some guidelines from the 29 party, but they have not been, in terms of anonymity and other issues that may apply to blockchain, but they have not been adopted. So we are kind of, in the air in this sense. So what are the possible solutions or recommendations? The solutions are, from a technical, you can see them from a technical perspective and from a legal perspective. From the technical perspective, the first thing you have to do is assess if blockchain is necessary, if it's the good fit for your project. Because if it is, it needs to comply with the GDPR. Now, the second, the most practical approach is to encrypt that encryption. So you encrypt the data encrypted goes in the chain, and the key is outside. So the way you exercise the right to be forgotten is by destroying the key. Now, then we have hashing. Hashing is heavily used in blockchain. So you store the data outside of chain, and you do the hash, which is a timestamp of the data in the chain. So the way you exercise the right to be forgotten is by breaking the linkage between the outside data and the inside data. Now, the problem here is it's well determined that hashed data and encrypted data are still personal data. So the regulators think, OK, that moves you closer to deleting data, but it's strictly speaking, you are not deleting the data because we still have data in the chain which is encrypted and hashed. So to fix this, what you have to do really is to find an encryption methodology that avoids identification of the individual, okay? And that brings us to anonymization. Anonymization is also a manner of exercising the right to be forgotten. Why? Because if you anonymize data, then the regulation does not apply. The regulation doesn't apply to anonymized data. What happened here is that there is a big debate as to how to anonymize data, so what you have to do in any case, a scenario, is to assess two risks, the reversibility risk and the linkability risk. Reversibility risk means that the technique you apply has to be so good that it's not only impossible to identify the individual, but also that the process cannot be reversed. And linkability risk means that encrypted data cannot be linked to that individual through other pieces of information. To the extent you're not able to meet any of those requirements, you will have, from a legal standpoint, you'll have to do an analysis of the possibility of identification of individual and take some measures to avoid that. Now, there are other possible options. I would make reference to public-private deletable blockchain infrastructure. This one, they combine public and private blockchains. So they put the data in the private blockchain, which is connected with a public blockchain, and then if they want to delete the data, they will just get rid of the side chain, and they will keep the public blockchain intact. Now, this may work for one or other use cases, so it depends really what type of project you are working on. Now, as we mentioned, there are other grounds, legal grounds. As I said, you can use the legitimate interest. With that would allow you to keep processing the data. Obviously, you have to inform the data subject beforehand. So you cannot use it when the right is exercised, okay? You have to inform beforehand. You can use the exceptions that will allow you to keep the data on the chain. And then this is a quite disruptive proposition, which is the waiver of rights. Why is that? Because I think data is an asset. And if the regulation is telling the data holder that they control their data, that means that they control and can dispose of their rights. So they can waive the right if they see any benefit. And blockchain is really quite beneficial in a sense that it brings security, it brings trust in consumers. So this is open. Now, as a summary, I think this is really a clash between promotion of innovation and protection of fundamental rights. In any democracy, obviously, there has to be a balance between the protection of data against other fundamental rights, which are also very important, like economic growth and security. Now, I think to regulators, they need to provide flexibility and legal clarity in their interpretations. They need to tell the industry how they apply the law, and then bring flexibility, because as we said, the GDPR is based on centralized systems. Therefore, they need to be flexible in their approach. To innovators, keep innovating. There's always innovation there that will help to really meet with this right. And at the end, I think it's collaboration between blockchain community and regulators. So the blockchain community will bring the spirit of the blockchain into the GDPR, and the GDPR into the blockchain. I think we should not see the GDPR as an obstacle, but it should be seen as a challenge to innovation for the protection of the data. Thank you. These are my contact details if you have any questions. Thanks.